So We the People News. Again, I'm not an attorney nor care to be an attorney. This is all a learning video and opinions. Okay, I never look straight forward. I always look around me to be able to protect myself by any means necessary. Alright, once again, it is a learning video. Okay, so we might as well just go ahead and start playing because there ain't a whole lot I can say.
Linsky, they apparently relegated the one course they have on constitutional law to an elective. Well, what the hell? Why do you want to waste time and money on the course you're not going to use when you get out there in the State Bar Association? It makes sense to me. But they're simply not teaching it, even in law schools of this purported caliber, and probably not much else, either to Harvard and fail. I mean, you probably have some elite corporate attorneys who maybe get some of this in case they run into kooks like us and have to deal with it. But most people today don't have a clue. But that's not our problem because they have sworn an oath to be bound, as I said earlier, by this Constitution. And we got to see when that's going to start to happen. A couple other notes here. We have a case from the California Supreme Court, thank goodness, in the days before Connie. Eleanor Valkenburg v. Brown, 43 Cal 43, 1872, after the ratification of the 14th Amendment, stating that no white person owed their citizenship to this amendment. True then, true now. It's a different body politic that was created there. And that's another exciting argument I'll be talking about on my u1incourt@gmail.com channel on YouTube, is that apparently that Constitution, and especially the amendments to it, have created a new body politic and a new state, but without the permission of Congress that would be required pursuant to Article 4, Section 3. It's not there. So to me, that brings up what I call the four magical words: the consent of the governed, and it ain't anywhere out there. We've not agreed to it. We've not made a voluntary, knowing, and intelligent waiver of any rights. And that's the reference standard of the U.S. Supreme Court. There's those pesky 9-0 parts again. Johnson v. Zerps, 304 U.S. 458. So they can't prove any of it. No waiver, no nothing, certainly no right to trial by jury according to the course of the common law. Oh, an interesting point there, by the way. If you can find it, you want to look up what we call the Report on the Civil and Common Law, 1 Cal Reports 588. Now, I happened to notice recently, this is a few years ago now, but I was doing some work in another city, Modesto, I think, and was in their law library, and they had a recently reprinted set of California reports, conveniently printed in Beijing, China. Would have been much more appropriate in Pyongyang, North Korea. We have the same democracy. But these pages were conveniently omitted. They don't want people to read this report because it was it was Bar San Francisco. A lot of attorneys talking way before the state bar ever existed about the pros and cons, and talking about a lot of the issues that we're talking about right now. So if we were admitted as a common law state, since when has that changed? What's the factual foundation and legal basis? I can't find it. If you have, I'd love to see it. So let me see some more notes here. Oh goodness, I lost my place here a little bit. By the way, the other thing with Adam's situation in particular, and with all of us, because you get into these situations where you're supposed to have a license. And those of you who don't know, the Black Law Library Law Dictionary, the definition of license: permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. Wait a minute, we created the whole government. When do we need their permission to do anything? Most particularly getting married for openers, and that's where they really get you, because they then monetize the birth certificates of your kids and now put them into interstate commerce. But when do we need their permission? They can't prove it. And when you go, for example, the vehicle code says no person shall drive a vehicle on the road unless he has the license. They can't even prove for persons, which are capitalized letters, by the way. And what that tells you is they're treating us as artificial corporate citizens. And wouldn't you know, that was a secret intent of the 14th Amendment, that nobody who ratified it, assuming they had the capacity to do it in any event, was advised. Here again, consent of the governed. Where is it? Secret intent. And I can't think off the top of my head, but a daughter of one of the late 19th century Supreme Court justices wrote a tract on the 14th Amendment that was supposedly enacted to help the freedmen and end slavery and all this. And at the time, she said there had been less than 10 cases that got to the U.S. Supreme Court on that issue. One of them was the well-known case of Plessy v. Ferguson, story for another day. But there were over 500 cases with artificial corporate entities. And even the Supreme Court, by the way, was apparently in the dark about this deception until the case of Southern Pacific Railroad versus Santa Clara County in 1882. It took them 14 years, and this idiot New York attorney that was on the Secret Committee of 15 came in there. I'll think of his name for you in a minute, and advised the Supreme Court that corporations were citizens pursuant to that amendment, and they reversed the decision they were going to make in favor of Santa Clara County, and it came out in favor of the railroad, who couldn't be taxed. This is the kind of nonsense we're going through with this crap, and it has to stop. But I don't know what's hard about this, John Roberts, or Samuel Alito, or maybe you political hacks on there like Amy Coney Barrett was, prone to saying, and maybe you really are hacks if this is the way you're doing your job here. Prove me wrong. Start doing it. Do the issues. Decide Adam's case. Decide mine when it gets there. I mean, it's absolutely ridiculous what is going on here compared to what should be. Oh, the other thing, by the way, that we have other rights that especially in Adam's case, we have an unlimited power to contract, a right secured by Article 1, Section 10 of the U.S. Constitution, which, as far as I know, hasn't been repealed. This right would also be available, particularly with the 9th and or 10th Amendments, and those do apply. As I said, the Supreme Court said the Bill of Rights doesn't apply to the states, Maryland v. Baltimore, but that's Articles 1 to 8. 9 to 10 too. Those articles do apply, and we have those kind of powers, and we're presumed confident, and that's the big deal, people, because this is the only nation ever created in history where the innate worth and value of human life is recognized. Life, liberty, and the pursuit of happiness. Never before, never since. I think this is the only nation in which we have a shot at getting it back. And if we do that, we set the stage for the rest of the world to follow suit. That's even better. But that's where it's gone with the 14th Amendment. What happened was they made us all equal. They sure enough did. Not by raising the freedmen to the level of state citizens, which could not have been done by that amendment in any event the way it was ratified, and that's with a capital R-A-T, because it would have had to been ratified by conventions of people in the states, not our agents in the legislatures, and certainly not the wartime legislatures that Congress created pursuant to the Reconstruction Act of 1867. And that, by the way, another reminder here, if I had learned that in high school, because the only thing we ever heard about Andrew Johnson was he was the first president that was impeached. They didn't tell you any details, nothing. He won the impeachment vote by one vote. But the reason he was impeached was apparently we were firing that Secretary of War, Edmund Stanton, which he should have been doing, and had every right to do. But that was the Tenure of Office Act, which the Supreme Court decades later ruled unconstitutional. If I had read his veto of the Reconstruction Act in 1867 in 11th grade U.S. history, my life would have been different there and then. And the funny thing for me, when I'm sitting there in South Carolina, that would have been my 50th reunion from my high school, and I wanted to go for that meeting to see if my ex-football coach / U.S. history teacher showed up. He did more than one thing in those days. And I would have said, hey, Vince, you missed a few things. He would have got the joke. But it's not there. You don't learn any of this in school. The history is so warped. I'm not even going to begin to get into that. You can check out my videos on my channel, When in Court, on YouTube. I talk a lot about our history with chemical and biological warfare and the state of wars at all, especially since the Spanish-American War. There hasn't been one that should ever have existed, but that's a story for another day. But my goodness, it's just so bad when you understand what's really going on here. And we're trying to fix, and it won't take a lot of us to do it. The good news about that is, a few of us crooks like Adam and I and some others that I've been helping, we get out there and do things and bring this to the attention of the public and try to force these people to do their sworn duty here. If we can do that, and that's why I never got to a trial in South Carolina, because I got real confident, quote unquote, and they knew they couldn't have me in front of a jury unfiltered by one of their attorneys. It doesn't work that way. It was not designed to do it. It won't now. But you have to have enough knowledge, and you don't need near as much as what Adam and I had to do, because they're so colossally ignorant on the other side. You start talking about even a couple or three of these issues with some serious intent here, you're going to get their attention, and they're going to realize that it's not worthwhile to have you go in front of a jury either, remembering that that jury has the power to rule on the facts and the law. Georgia v. Brailsford. And that's the ultimate check and balance on these bastards, and they can't take a chance on having that happen in any way, shape, or form. That's what's still there, and that's what we have to get back. Oh, here I go rounding again. I know.
You're great. You're so great. Georgette, you have something to share?
Oh, go ahead. I'll pick up in a minute. I'm going to check my notes, but go ahead,
Okay.
Adam. I'll review some things while you're doing that. Yeah, I got that one. Got that. Oh, just a quickie here, by the way, about needing a license, and their permission. Now, if you need a marriage license, and their permission to get married, you just wait. It hasn't happened yet, but it's going to. They may start in Texas, where they pass a law to declare that an unvaccinated parent is per se incompetent, and the Child Protective Services can summarily remove your child from your custody, and you never see him again. You wait. That one's coming. You just know it is. Another thing, by the way, on this subject, you just wait for the case in Minnesota up there with George Floyd, and you just wait. That conviction is going to be reversed sometime next year when the temperatures have cooled down. This, that, and the other going to reverse it, probably on the grounds of juror misconduct. And what may happen is, I can't think of the guy's name right now, but he's going to get probably a reduced sentence like what happened out here in California with Johannes Measurely, and who got murdered in a BART station here. And the idiot that did it ended up getting, I think, 18 months in jail and got released in under 14 for good behavior when he committed what was at least second-degree murder, if not first-degree murder. And yet, had the situation been reversed, you can be sure this victim would have been charged with first-degree murder. But guess what, people? There's those pesky 9-0 parts again. You have a case called John Badoff versus United States, 177 U.S. 529, in which they reversed the conviction for a man who was assaulted, and this was at the time in the territory of South Dakota, on an Indian reservation, by what represent peace officers. Now I call them law enforcement thugs. I don't know when that change occurred, but it wasn't when I was growing up. And they said, well, we have a right to self-defense, and the law enforcement officer didn't have a warrant, didn't have probable cause. And they further said on the facts of this case, you probably couldn't have convicted that off of manslaughter. That's what we need to get back to today. Hopefully we're not going to have a lot of run-ins of this type, but we have the right to self-defense. If they're trying to enforce laws that we know and can prove don't apply to us, and we have no forum in which to make those points, particularly to a jury, what are we supposed to do? Just a little food for thought here.
Well, that's where we are. That's where we are. Georgette, did you want to share anything about your case and how some of the these issues are? I mean, essentially, what happened in your case, if you want to talk about it, is that you were denied the right to a hearing as well, even though you were there.
Nothing's coming to me about it. I'm doing another appeal with Adam's help. And, putting one foot in front of the other and doing what I said earlier, just keep standing in, I do not consent to that fraud. I consent to this truth, that kind of thing. So
just to give a little bit of reference, what happened for her is she's going through. They're trying to foreclose on her for allegedly not paying some money that's due to the mortgage company. So they conducted a hearing, gave her notice of the hearing, and then in that hearing, the judge issued an order that the foreclosure sale could move forward, but then they never gave her notice of that judgment order. So she called the court about 3 weeks later and said, what's going on with the case? Well, they told her at that time that an order had been issued. So immediately within the 10-day statutory period, she filed notice of an appeal. That was to be, I think it was October 5th. So she shows up at this hearing on October 5th, and the judge says, well, you didn't file a timely appeal. You were without the 10 days that you had from statute from the time the judge issued the order to the time you had to file notice. And she said, well, wait a minute. I was never given notice of the order. So,
and he said, I know, and I have to follow what I think is the law.
So, of course, our whole argument is, based, principally on due process or judicial process. You have to give people notice. That's essential to everything. And they did not admit one single item of evidence in her so-called hearing that showed that she was ever given notice of the foreclosure sale. And of course, I know Bill's over there he's writing a whole new habeas corpus over there for her, to find dollar and urine admiralty and foreclosure and
I did
going with the simple stuff here, but the whole basis of this is that because the judge had no authority to deny her a hearing, that's treason. He just literally exercised the judicial power of North Carolina to deny her a constitutional right to a hearing where that whole proceeding that took place was also without jurisdiction. So it's now she's filing an appeal to that, only to have, probably if they even find in her favor, to have the case sent back to the court so that she can have a hearing and present evidence. Well, it's not even her burden, that the foreclosure sale had no jurisdiction. So anyways.
There was one other. Did you finish?
Yeah, I just wanted to say it's not just Bill and I that are, doing this. Georgette would readily admit, she says, I don't know any of this stuff that you guys know. And yet she's being empowered to stand in her power and, learn these things. And go
to court and shake like a leaf and, speak my piece.
Well, I, as you well know, I've been there, done that too, shaking and stuttering and just not knowing what to say or what to do. And, obviously that's changed now, but, that's it. You're engaging in it and you're not running away from it. And, you're showing up even though there might be trembling in the body or you might be experiencing fear and you don't know what to say, but you're showing up. And then as you do that, the same in my case, and Bill will attest the same thing. The truth always reveals itself. It always does.
And, I found one other little thing in the judge's order that was not, that I didn't get notice of. And it said this. I just want to share this with you all. It says that, let me find it here. She's giving an order for a new foreclosure sale for the real property, which is the subject of the above captioned special proceeding, being conducted subsequent to substitute trustees meeting all notice requirements.
Yeah, well, they didn't meet the notice requirements.
Yeah, so they can't go on with the sale because they didn't meet the notice requirements. That's what this is saying.
Yes, exactly.
Okay. I just wanted to make sure I was understanding.
Well,
it right.
actually, maybe that I might be incorrect about that. What it may be saying is that if the substitute trustee complies with all the notice requirements required to give you notice of the proceedings, then those proceedings can move forward. But again,
That's the way I understand it.
yes, but that hasn't happened yet, so it's not something that they haven't complied with. If that makes sense. This is what they're talking about is a future proceeding. So in the future, as long as the trustee complies with those notice requirements, the foreclosure sale can proceed. But what he doesn't know yet is that that special proceeding that they had was void, and that you're challenging the jurisdiction of that proceeding. So it's not going anywhere. So he had no lawful authority to make that order, because he could only make that order if he gave you a hearing and heard your challenge to jurisdiction, which he
No,
did.
this was in Finkelstein's order
Oh, I thought
back August 10th.
Okay.
No, this is August 10th. And I didn't read the whole thing. It says, subsequent to substitute trustees meeting all notice requirements as stated in the terms and conditions of the documents and by relevant law.
Okay, so yes, if you roll back the clock, they never gave you notice of that order, so they never had authority to present the foreclosure proceeding. And again, this is aside from all the other way big constitutional issues that we talk about. We're just keeping it on this, their playing field right now, so to speak.
Yeah,
and
I just wanted to share that with you.
Yeah, no, thank you. That's great.
And I'm so proud of myself because I noticed that.
And you should be. But I mean, that's the beauty of what's happening is, Bill, she's calling me, sometimes 2 and 3 times a day, or emailing me and telling me about these things that she's found. And it's just so beautiful because she's engaging herself in reading this stuff and, going through the motions of like, well, what does this mean? And, she'll ask. And then, now she's starting to put all the pieces together to see, even in this scale, even just at the so-called statutory level, that they're just a disaster. They don't follow their own rules, and I don't know if they know what they're doing or they don't, but it's an atrocity.
And I must add that Adam helps me keep focused. There are times that I call him or send him an email saying, what about this? Nope, forget it. So there's that too, and I thank you for that.
Oh, you're so welcome, sweetheart. You're so welcome. Yes.
If I might say.
Okay, we're going to stop it here. And there you go. I believe we just got one more. Alrighty. We're going to end this video.